We'll call the first case, White versus White.
Good morning. May it please the court, my name is Steve Gardiano, and I represent the former husband, James White, in this dissolution of marriage. I would like to reserve 5 minutes for rebuttal. The thrust of my argument in this appeal is best viewed by the trial court's opening statements of the trial. You have a situation where both parties were not working. The husband had had a successful career and had allowed his company to be bought out by Robbins and Myers in return for stock and 5 annual payments. So both parties had merely income-producing assets and payouts from the Robbins and Myers stock. The only thing for the trial court to do was delineate these assets and income and divide it equally according to his scheme of equitable distribution, where he said, this is a 20-plus year marriage, I'm going to equally divide the assets. That is my intent. Hence, there was the trial court's dismay at the beginning of the trial when he says, why were the parties not able to settle this case prior to bringing it to trial? All you have are assets. We don't have an alimony issue. All I'm here to do is basically divide the assets. And so from the trial court's perspective, this was a relatively simple case.
Wasn't it made more complicated by difficulties with discovery or failure to provide discovery?
Not really, because in this case, the thing that was interesting or made this case unique is that you did not have a case that went to trial within a year of filing the lawsuit. The parties had separated in October of 2000 and had been separated up to and including the time of trial for a period of 5 years. So what I think what happened was basically you had a moral drama. Something that was supposed to be a simple division of assets became a moral drama. And with all due respect to very experienced trial counsel for the wife, he was able to castigate the husband and blame him for the failure to disclose where assets that were known, everybody knew about the assets, what he did with them afterwards when he was separated. And that
Didn't the trial judge find there were some non-disclosures? Weren't there some bank accounts in Ohio, for example, that the husband owned that he didn't disclose?
He didn't disclose things that had occurred after the marriage, but...
After the marriage or after the separation?
I'm sorry, after the separation.
Still part of the marriage at this point until the final judgment, right?
Yes.
Doesn't he have an obligation to disclose it even if it's post-separation, if it's pre-divorce?
Yes, he does have an obligation, but...
So there was a problem with your client not disclosing things he should have disclosed. Is that correct?
There was definitely a problem to that in that regard, and with the trial court properly assessed an attorney's fee award against my client for that. I don't believe that that gives the trial court the right, and I'm not saying he did it because of those reasons, because he didn't. He said he wanted to achieve an equal, equitable distribution. And what I'm saying here, as a result of how the husband was castigated as being such a poor individual, almost transforming Florida from a non-fault state into a fault state, because there was no demonstration of dissipation of those assets, merely a concealing of those assets, there resulted in a substantial number of...
Well, which is worse, concealment or dissipation? I mean, they're both equally bad, aren't they?
No, because in this case, he didn't conceal. Everybody knew that the assets existed because they were generated from the Robbins and Myers. There was a payout over the years, 5-year payout, 2002, 2003, 2004. Everybody knew he had received the monies, the $1 million, $1.3 million. The problem was there was a failure to disclose where those assets had been placed. They still existed.
As a matter of fact, opposing counsel had to spend a considerable amount of time and effort and resources to locate assets that your client didn't disclose during the proceedings. Isn't that correct?
No.
That's not right.
It is not correct because the assets were known. The parties had separated.
If they were known, then why didn't your client properly disclose them when he was supposed to?
I can't explain my trial counsel's actions. Perhaps he believed that once the parties were separated, what he did with his money or where he placed it was something he chose to himself. But the bottom line here is the assets themselves were not.
Let me move on.
In other words,
let me move on to something else.
Okay.
The process supply of Pittsburgh stock. You complain that your client wasn't given a special claim or special equity in that as he sought in the lower proceedings. Is that right?
Yes, I do.
Well, listen. My question to you is, in reading the final judgment, the trial judge certainly considered that and came to a different valuation than you did, didn't he?
He came to a valuation of $40,000 based solely on the finding that the parties lived in a modest apartment at the time of their marriage.
Well, he also says that your client offers nothing but his testimony to support that value.
That's
and
not
so,
correct.
I'm quoting from the final judgment. And so, the clear implication to me from that statement is that although your client testified to a certain valuation, the trial court just didn't accept it or believe it. And if that's the case, how do we say that the trial court erred in arriving at the valuation that it did?
Because there's the only substantial competent evidence to support his determination of a $40,000 value is that the parties lived in a modest apartment. That's a supposition that isn't supported by the evidence. In fact, there were the husband's value of the process supply of Pittsburgh was you had the parties' 1978 tax returns, which showed that back then in 1978, the husband was making over $100,000 a year in real money. And you also had substantial competent evidence in the fact that the parties built the former marital home without a mortgage whatsoever. So if the bottom line in discretion with regard to these types of determination is there substantial competent evidence to support that ruling? The only substantial competent evidence was the trial court's finding, they lived in a modest apartment. He was a bachelor at the time. Of course he lived in a modest apartment. But immediately after the marriage, they went out and built and purchased the land and built the home for a marital residence, and there was no mortgage on it. That supports that he was a man of income. Plus you have the unrefuted tax return showing that he was making over $100,000 a year. Let's look at Mr. Pankrantz's testimony. As I pointed out in footnote 2 of my initial brief, even he himself ascribed a value to the stock of the 4 shares of stock, which when multiplied over the 44 shares, at the very least there was a value, a premarital value of $574,000. Next point with regard to that is that the trial court himself didn't allow Mr. White to testify. He initially said, and this is delineated in my reply brief, I believe it's at volume 13, T200 to 220. Initially, he allowed Mr. White to testify regarding the value of his company, and then he sustained an objection saying, I didn't really think it through. He can't testify as to the value. So I think the trial court was stuck by that. I think going to point 2, and this is going to the case, even Judge Palmer has indicated in his opinion in Doyle, at 789 Southern Second, and I forgot the page site off the top of my head, that even though a trial court has broad discretion in distributing property and making equitable distribution, it has to be reversed where there are plain errors on the face of the judgment, in this case mathematical errors. And really a good summary of this is the judge indicates that there were $19 million in assets. And in his equitable distribution scheme, he gives $9.5 million to the wife, $9.5 million to the husband. There weren't. There was only about $14 million of assets. This court should reverse and remand with specific directions to correct the apparent errors and faces of double charges and double dipping. And they're outlined in point 2 of my brief, but I mean, they're quite substantial.
Isn't part of your argument about double dipping dependent upon accepting your client's testimony that certain monies went into certain assets? And you counted double dipping because they counted this money here and then counted the asset that was bought with it. Is that part of the double dipping argument?
That may be part of it with regard to some of the issues. But, for example, the trial court, on the face of the judgment, found that the $612,000 in payments to the wife are disbursements to the wife as marital assets. There is nowhere in the face of the final judgment in the equitable distribution scheme, after making that comment in paragraph 12, he does not indicate that the wife received $612,000. Then, correspondingly, the trial court did not delineate that $612,000 should be deducted from the husband's side, so that translates into a $1.2 million difference. That isn't dependent on any testimony.
Did they put in the husband's column what he'd spent to live during the 5 years of separation?
Actually, what the trial court did, and that is also reflected in the judgment, for example, the husband purchased jewelry, cars, etc. Those are put into the final judgment.
So all of his living expenses for the 5 years of separation included in his column. Because as I understand it, the $612,000 is everything he gave to her for her support during those 5 years, correct? Am I correct on that?
The $612,000
is the temporary support, but was then ultimately determined to be equitable distribution, correct?
True. It's equitable distribution.
So you want in her column everything she was given to live on during those 5 years, correct?
No, I want since it was equitable distribution and she did receive the $612,000, I want that to be reflected properly as a distribution of a marital asset. For example, the trial court delineated the R&M, the Robbins and Myers payouts of $1 million per year. Those were listed out. He obviously used those for living expenses. So, no, I don't think those have to deal just with living expenses at all. I don't think that's supported by the record. It's a matter, again, of mathematical calculation. The trial judge himself was the one who termed these payments as equitable distribution. He can't then refuse to credit the husband and debit, or credit the wife and debit the husband of those payments. That's $1.2 million in itself. Then you have the Hempstead property, another significant asset. That was a double charge. There was a $550,000 withdrawal from Bank One. Even trial counsel's, wife's trial counsel admitted $325,000 went into the Hempstead home. So in other words, on the husband's side, he's charged with the $550,000 and the value of the home. That's a double dipping. It's a double charge. And that's acknowledged by the wife's trial counsel at volume 15, transcript 434. And then even the trial court on the face of the judgment indicated in paragraph 11-0 that the husband used at least $300,000 of that for the closing on the property. That's a double charge. That's not dependent on any testimony in the evidence.
What about the trial court, and if we're talking about paragraph O, the trial court's statement that he failed to maintain complete records under those circumstances and it's beyond comprehension. Did that have any effect that the trial court perhaps thought that it wasn't documented, there weren't records to support that claim?
There were records produced.
Why did he put that in the final judgment then?
With all due respect to the trial court, and I greatly respect Judge Kennedy, in this case, and it's really reflected at the end of the motion, in the transcript of the motion for a hearing, he castigated moral blame on the husband for not failing to take proper care of his wife, for allowing the divorce for allowing the marriage to stagnate and the divorce to happen. And a lot of those findings I don't believe are supported by the evidence. I think, again, like the judge said, this was a simple case. All you had to do was
So basically your argument is that the trial judge just maintained too much sympathy for the wife, and that's why the trial judge put statements like that in the final judgment?
Yes, I didn't catch it. And then
and that was because of what reason? The wife was ill, or why would you do that?
It was at trial. It came out that the wife had an undiagnosed benign tumor in her head, and that prevented her from working. As indicated in the factual portion of my brief, didn't prevent her from enjoying life to its fullest. and basically driving around Harley Davidson on motorcycles, European
And
tours, and whatsoever.
she truthfully disclosed all that too, didn't she? Was there any evidence that, that the wife concealed assets that were requested through the discovery process of the proceedings like the husband did?
The wife did not receive many assets, but
Is there any showing in the record that the wife attempted to conceal assets similar to, what the husband did in this case?
no, there's no evidence of that. But I really seriously dispute. He did not conceal assets. The assets were known. They were known distributions of R&M payments.
He didn't disclose assets when he was supposed to.
No, he didn't disclose where the payments went.
Is
That's
that
different
perhaps
than concealing
why the
assets.
trial judge was a little bit skeptical about some of these claims and led the trial judge to put statements like that in the final judgment?
I'm sorry, could you repeat that?
Never mind.
No.
I'm concerned about your statements about the importance or non-importance of failure to disclose, that the mere fact that the distribution was known means it's no big deal if they don't list what the assets are as of the time of the trial?
At no time do I say this is no big deal. The question here is what's the proper punishment for that? If you fail to disclose, the proper punishment is imposition of sanctions. We have $200,000.
Well, I mean, there may be
in sanctions that were
punishment too, but the
imposed.
trial judge has the right to take that into consideration in determining the weight he's going to give the evidence and who he's going to believe, doesn't he?
That's true.
I mean, that seems to me a primary problem that you've got throughout these proceedings is that when your client did those things, he lost credibility with the trial court, and I think appropriately so.
I can understand that, but it doesn't affect the fact that the final judgment on its face, based on the findings by the trial court himself, resulted in double dipping, double charging, which this court, just relying on the face of the judgment, can look at and direct the court to make those appropriate credits. And with all, opposing counsel's argument on his cross appeal is to the effect of there shouldn't have been an equal distribution, which is what the trial court asked for. Well, with all due respect, that argument is waived from appellate review. It wasn't raised below, especially in the light of the fact that the former wife's trial counsel specifically said we want an equal distribution of the assets. I do want to reserve a little.
Okay, you've got 2.5 minutes left. Judge Munyon, did you have a question on that?
No.
I've got one. The inheritance issue.
Yes.
Your third point, are you still making that argument, and how do you make that argument when your client's own testimony was that assets were commingled?
The asset was not commingled. It was placed into an account with just his name on it. That is the testimony, and I think I detail exactly the record cites. That was in an asset with just his name on it. Where's the evidence of commingling? I don't see any in the record whatsoever.
Okay, you've got 2 minutes left.
Please court, Horace Smith, a firm of Smith, Perkins and Hood in Daytona, Smith, Hood and Perkins in Daytona Beach, representing the former wife. Right from the beginning, the case was one in which there was a problem of concealment, subterfuge throughout. The former husband had filed financial affidavits in West Virginia and financial affidavits in 2002 in the state of Florida. In both of those financial affidavits,
What about his argument that the trial court failed to properly credit, was it the $600 and some thousand payment that, or monies that were paid to the wife? What about his argument concerning that? And that should have been put over as a credit.
What the court did in West Virginia and in Florida, pursuant to a stipulated agreement between the parties, awarded the wife $12,000 per month as living expenses. This amount, the court, from the beginning, at the beginning of the case, said, I don't know whether to treat this as alimony or equitable distribution. I need to hear the evidence. The evidence was that the husband had total control of the $19 million of assets except for the condominium in which the wife lived. He had everything, $19 million. She had no funds. She then got the $12 million. All of the funds were marital. he continued living his lifestyle. And the judge, yes, she got the $612,000. The husband continued his lifestyle. According to his financial affidavit, he spent $9,000 per month just from his affidavit alone. That was not considered either. So if you take the
So
same,
that's basically an offset
it's
on
an
both
offset.
sides?
His living expenses, her living expenses, neither one were put into the equation. As I was speaking, in 2002, the husband filed an income or affidavits. At that time, all of his affidavits, all of his interrogatories, and we're talking 3 affidavits, we're talking about 2 sets of interrogatories. All of them indicate he had 2 bank accounts and 2 bank accounts only. Also indicate his total income was $100,000, those coming from the joint investments which they had. After the hearing in which the wife was given the $12,000 per month, the husband shortly thereafter filed a motion to modify, saying, I cannot afford the $12,000 a month any longer. I'm going to have to dissipate assets to do so. The hearing was heard by the court. That was denied. Later, 2 years later, 2 more depositions later, we learned that at the time the husband had filed that affidavit, he had sitting in a bank account over $1 million that he had received just 1 month earlier. So he'd gone to court and advised the court he had no funds, had no other income, and yet his income for that particular year was $1,100,000. Happened to miss the $1 million income. So that's the way the case sort of began. So we started investigating to his bank accounts because we didn't know about the $1 million of that. That was not learned until 2 years later. We investigated to his bank accounts. We asked him on 3 separate occasions, once in open court, 2 on deposition. What other bank accounts? We asked him in interrogatories. What other bank accounts? Notice to produce. What other bank accounts? They were consistent. 2 bank accounts, 2 bank accounts only. I have no other bank accounts. 2 years later, we learned he has 8 other bank accounts. He has 3 in SunTrust, each one of them from one in 2002 in February, 2003 in February, 2004 in February, a distribution from the stock of over $1 million per year. None of it ever disclosed. He also has 3 bank accounts in Racine, Ohio, a small town that's not even on the map. Its own bank run by one of his friends, in which he'd also had $1.02 million from various times. We found a bank in Brevard County simply by finally, luckily checking that he had a bank account, a Colonial Bank in Brevard County, which he denied at all times. When we finally produced to him that you had a bank account, he said, well, I forgot about that particular account. That account had over $300,000 in it. Consistent, we took his deposition, and finally, at the time we took his deposition, we only knew about the $1 million payment that he had denied ever receiving. When we took his deposition and asked him about the $1 million payment, where it came from. You haven't disclosed it previously. Where did this payment come from? He advised at that particular time that what happened was he had pledged the stock, 238,000 shares of stock that they had received from sale of the company, that he had pledged it, that he got it for collateral. And as a result, he had worked a deal and made a profit, and that's where the money had come from. We asked to see those papers. He didn't have them at that time, so we asked again. He then admitted that there was no pledging, there was no collateral, that what happened is he had received it in another type business transaction. Still not revealing the fact that he was getting $1 million a year for the 5 years. Did we know about the sale of the company? Yes. Did they produce the sale paper? The answer is yes. They finally did in volumes that stood about 4 feet high on 2 sacks. However, the key page was missing. The key page to the volumes was blank. And that is in the evidence. And we introduced in the evidence that it showed no payment coming out to him when we requested the payments on more than one occasion. In fact, after I found out about the payment, now knowing where it came from, I gave him the opportunity to tell us about it. and he gives us another story about these payments really not coming. When we finally tie him down about has he received any other payments, and he denies it, I ask for a return, a tax return. He produces his 2002 tax return in 2004. His 2002 tax return, which is produced, shows an income of $100,000 approximately. That didn't jive very much because I knew of an interest payment on the $1 million that he did not reveal in the account that gave us at least $15,000 in interest. So I was wondering why it was not on the return. So I gave him another opportunity after receiving the return at deposition. Is this return a correct return? Yes, it is. Are you sure? Yes. Why doesn't it show the interest that you received? That must be a mistake, but it is a correct return. I then say, well, my accountant would like a certified return from IRS. I don't give that to you. The judge finally says, give it to him. We finally get a new return and learned that the first return was never filed, even though it was signed off by a CPA here in Norman Beach. The first return given to me and testified to him on 2 occasions showing $100,000 was incorrect. There was a missing $1 million, the one that was in the Sun Trust. And also, the new return also included the Sun Trust accounts. Even then, did not include the other Sun Trust accounts. And at the same deposition, I asked him if there were any other accounts, and he said no. And I asked him if he had withdrawn any other money, and he had said no. Further records after the deposition disclosed that on the morning of the deposition, he withdrew $1 million from the Sun Trust account. An additional $1 million did not advise us about the deposition. Throughout the case, it was a case of hiding bank accounts. As to the Hampstead property, it was never admitted, and you can look at the record, I have never admitted that the $500,000, which the court charged him with, that was a double dipping that counsel claims. I gave him the opportunity, stating, well, you took $500 from bank, $500,000, $550,000 from Bank One. Where did it go? I don't know. Well, thereafter, some 6 months thereafter, you purchased a property, which he originally had denied. He originally denied that his girlfriend had purchased the property, and he had paid her back in cash. That was the first deposition. The second deposition, when I showed him that he purchased the property, it was in his joint names, he said, that's right, she paid me back in cash. Finally, when I came up with a check showing that it came solely from his bank account, he admitted, yes, I bought it, but she paid me back in cash. But then I gave him the opportunity. Well, maybe that's part of the $550,000 that you removed from what you did with 6 months ago. He denied that. That's not necessarily not the case, he says. There has been no double dipping. Each item, and on the brief I specify each item that's outlined by counsel that would be a double dipping and shown why it would not be. In fact, the items he claimed was double dipping was actually purchased, most of them, prior to even the separation of the parties. And so I've gone down that one by one. Now, he claims that some of the wife's property was not included. But what happened was that the judge finally, after 4 years, and we discovered that he had received over $3 million, all that she had not disclosed, the judge said the next payment, the wife ought to get it. When she got that payment, she then made expenditures that she had not made in 3 years. She bought several new automobiles, and she also loaned some money to her father. They want to claim the money as well as the money that she bought the automobiles with and money that she loaned to her father. They want to add that twice. That would be double dipping. The court did not do the same thing on his part. It should not occur on her part. On the inheritance, clearly there was at most, or on most favorable light to the husband, at most there was commingled, or it was commingled funds. The husband had claimed originally that he had received a $15,000 inheritance. That was his first deposition. asked if there was any more. He said no, that was from a life insurance policy. He later, about a year later, indicated that he received some $235,000. When we had discovered that he had purchased, after he denied it, over $91,000 of jewelry, a Jaguar, and some other items for other people, we asked him where the money came from. He says it came from my inheritance. The problem was all of those were purchased almost 8 months prior to his receiving the inheritance. He then later said, well, I knew I was going to receive the inheritance in the future. Therefore, I used these marital funds to purchase these items. The inheritance replaced those marital items, and I put it back into the joint account. When you look at even the inheritance on the face side of it, he received the entire inheritance from his mother's estate. If you divide that inheritance by 3, because it was he and his brother and his sister, the sister received hers penny for penny on the even division. The brother received his through loans that he said that he made to the two particular brothers. So throughout the case, as the court had indicated in its final judgment, it was necessary that we discover items that never were given to us. It took us over 2 years. It was not a simple matter of discovering these items. It took us 2 years, several trips up north to various different cities, subpoenas, some of which were not even honored. But still, we were able to finally locate some of the banks that we were given, and some of the funds. Notwithstanding the fact that we located this, and for example, the husband claims, well, the wife's double dipping because she didn't count her jewelry because there was an insurance policy. One of the things we located was that the husband collects old cars, and we found some 12 or 14 antique vehicles worth in excess of $350,000 that he said he did not have. When we finally located an insurance policy in the state of Michigan, where he had taken out an insurance policy insuring these particular vehicles, his explanation was, oh my gosh, I've been paying on a policy that I haven't covered. The court, even though he had this insurance policy, still gave him the benefit of the doubt, saying, well, you didn't produce the cars, you have not shown the cars, even though we showed that one car came back into his name, which he tried to explain away. The court did not even give us credit for that particular one either. So, as I said, I've gone through each individual item that they said was a double dipping and shown through the records that there was not a double dipping of that. The wife, even though the court made an equal distribution, I think the wife was shortchanged. Yes, she got her attorney fees paid for because of the misconduct, but nevertheless, a person who conceals, hides, and in this particular case, we're talking over $3 million, when they get found out about it, saying, oh yes, well, I owe you half of it. That shouldn't be the standard. Thank you.
Before you leave the podium, would you address your motion for attorney's fees on appeal and the basis on which you think you're entitled to appellate attorney's fees?
Well, the same reason that as in the lower court is that this case is only here because of the misconduct, and as a result of the misconduct is the reason.
Thank you.
Would you address first opposing counsel's argument about the double dipping argument, that being that the record does not show that the husband was able to tie the specific fund of money to the monies that went into the purchase of that house that you say is part of the double dipping?
Well, depending on exactly which fund, which fund are you making reference to?
Well, I think the double dipping refers to what's called the Hempstead property.
Yeah, the Hempstead.
Where did the money come from, and what did the record show as to whether or not the husband was able to show that the money came from a specific source to go into that purchase?
With regard to the Hempstead property, specifically as detailed in the brief, the husband testified that it came from and this is in volume 15, transcript 434 of the record, the 1028 Hempstead Lane property. Even the court itself in paragraph 11O of the final judgment said that the $550,000 withdrawal was used for the Hempstead property. So you asked me to go to the record. I'm saying it's actually in the face of the judgment as well that the $550,000 in that bank account went to purchase the Hempstead Home Lane property. The trial court indicated that. Trial counsel himself admitted $325,000. So right away, there's a double charge there that's supported on the face of the judgment itself as well as the record on appeal. Paragraph 11O and volume 15, transcript 434. He should be receiving at least a $325,000 credit. The question before this court is whether it is going to affirm the opinion in the face of clear mathematical error on the face of the judgment. And that mathematical error was not caused by trial counsel's failure to disclose.
You said earlier in your presentation to us in response to one of the questions that, and I think you indicated that it was appropriate for the trial court to consider and award attorney's fees for any misconduct on the part of your client in the proceedings below.
Yes.
I think you indicated that.
Yes, I did.
Would it therefore be appropriate for us to issue an order awarding fees, appellate attorney's fees in this particular case to the appellee?
None whatsoever. I don't see any failure to disclose. I believe my arguments are meritorious. Well, the first thing the court considers is the relative financial condition of the parties. $9.5 million allegedly was distributed to each, although I'm contending actually there were only $14 million. She got $9.5. He got $4 million. So then you have to look at the conduct of the parties. The conduct of Mr. White in this appeal, there is nothing to indicate a failure to disclose whatsoever. I don't think that should be allowed to
I'm
go
not
on.
saying how we're going to rule. We have to go back and we have to discuss the case and determine whether we're going to affirm, reverse, or partly affirm, partly reverse. But my question to you is a hypothetical. If we affirm on all issues, then what is your position regarding attorney's fees?
I don't believe there's a basis for attorney's fees because I do not believe that any misconduct has been shown whatsoever in the prosecuting of the appeal.
Let me ask you one question arising out of your response to the motion for attorney's fees. You say that the wife's pleadings claim that the husband provided a fake income tax return, committed a fraud, and imagines a fraudulent scheme, when in fact most of the wife's claims of fraud and dishonesty were fully explained during the trial. What was explained during the trial with regard to the tax return that was referenced by opposing counsel that was claimed to be the final tax return and turned out to be way grossly less than what was in the final tax return that was filed?
Okay, that is contained in my reply brief regarding the false tax return. There was not a false tax return. As was explained at the trial itself, and I actually had found it just before I came up here. I believe it's in my reply. On page 26 through 27 of my reply brief, in 2002, the husband had a Florida firm prepare his tax return. He had always had his tax returns prepared in West Virginia. When he got it back, he said it's inaccurate because it failed to include the computation of deferred compensation payments. So he then sent it to the West Virginia firm, who then redid his taxes. But his trial counsel, as part of discovery, provided that earlier Florida tax return, which was then seized upon by experienced trial counsel.
And did your client swear under oath at deposition that that was the tax return that was filed?
If he did so mistakenly, and actually...
Or at least that was his testimony, which it was up to the trial court whether to believe or not, correct?
No.
Trial court could have decided that it was a fraudulent nondisclosure and not believed your client when he said it was just a mistake that I produced that one and not the actual.
That would be true if he hadn't disclosed the 2002 West Virginia tax returns, but however, those were disclosed as well. And that's in the record on appeal. And the specific volumes in the record I'm referring to are volume 12, transcript 54 to 56, and volume 14, 329 to 334. At trial, he explained he thought it was the one that he had filed, but it wasn't. It was the West Virginia tax return. Bottom line of the argument is, and that is where my brief primarily lies. Relying on the face of the judgment, there was double dipping. This court may not agree with my client's conduct with
You need to
regard.
wrap it up because you're way over your time.
Okay.
All right.
The failure to
Quickly.
disclose assets were assets that were already acknowledged, and as indicated in the initial brief, the wife admitted all the assets were known. What you have here is the failure to disclose after the separation of assets that were already known
Okay,
by the parties.
thank you.
Thank you very much.
Way past your time. Thank you. All right.